Testing Justice 7. Testing Justice 6. Testing Justice 5. Testing Justice 4. Testing Justice 3. Whoops. Testing Justice 2. If I missed the first couple. Testing Justice 7. Testing Justice 6. Testing Justice 5. Testing Lavalier 2. Testing Lavalier 1.
Justices of the Supreme Judicial Court, City Law Court at Portland, within and for the state of Maine, may come forth and declare, and they shall be heard.
Good morning, you can be seated. The matter before the court is Androscoggin 25-7. This is State of Maine versus Heather. Is it, how do you pronounce it? Is it? It's Marichal. And we are being streamed on the web, both by video and audio. Before we begin the argument, I'd ask counsel to identify yourselves by saying your names for the record, starting with the appellant.
Julia Casey.
Patricia, Assistant District Attorney.
Thank you. And Attorney Casey, if you are ready to proceed, we'd be happy to hear your argument this morning.
Thank you. Good morning, and may it please the court. This case is about a defendant's right to present a complete defense, her right to call witnesses in her favor, and her right to a fair trial. On September 30th into October 1st of 2021, this was the worst night of Ms. Marichal's life. What started as a first outing after 18 months of a pandemic turned into an arrest in a night that she has no recollection of.
Counsel, I see that the green light is on. When it came to this trial that was actually held in this case, or the trial date that, after many continuances, finally came to fruition, was this witness, was it Mr., I forget his name.
Mr. Johnson.
Thank you, Mr. Johnson. Was he actually subpoenaed for this trial in December of 2024?
He had been subpoenaed multiple times prior to
He had
December.
been subpoenaed by you successfully once and by
Yes.
the state twice.
Yes.
And I understand that those subpoenas were, the first was in, let's see, January 29, 2024. He was subpoenaed by the defense and served on January 30th. Then he was subpoenaed apparently by the state on July 11th, 24, and on 11/27/24. After all, this was, I believe, the 9th or 10th docket call for this case. So he was subpoenaed those 3 times, correct?
That's correct.
Was he subpoenaed for trial for December of 2024?
I don't believe that he was, because the capias had been in effect at that point, and I think it was the defendant's position.
So in other words, he had no reason to know he was supposed to appear for trial in December of 2024 because he had not been served the capias and there had been no attempt to subpoena him.
There had been no attempt to subpoena him, that's correct, but at that point, it's the defendant's position that it was on law enforcement to execute the arrest warrant that was ordered by the capias to secure him for trial, because the several attempts to subpoena him had been he had successfully been served, but he just simply did not appear any of the dates he was
served for a
supposed
different
to.
date, though. That's the problem, right?
That is the problem, but each of the times, after 3 times being served, he didn't show up. I think his intentions were pretty clear that he did not intend to appear.
So did you or trial counsel make any efforts? I didn't see anything in the record. Is there anything in the record of efforts to have him, either the capias served or other efforts to have him appear for December?
There is brief reference in the motion in limine that the trial defense counsel had made efforts and calls to various sheriff's offices to see the status of the capias. So those were the efforts that defense counsel made. It's not the most robust record, but it is indication that defense counsel didn't just sit and wait for the law enforcement to execute this warrant. There were efforts to check in and see the status of it, but to no avail.
How many continuances or false starts were there here? Have you counted them
There were
up?
a lot. I think I counted 7 docket calls, but as
9.
9. Okay, I'm sorry, I miscounted.
So here's the poor judge sitting there saying, okay, we're trying to get this witness, motion continue granted, motion, okay, we'll bump it ahead, motion continue granted, and finally it comes up to this one here, and the judge pretty much throws her hands up and says, can you give me any guarantee that we'll get him the next time? And counsel is unable to say, well, no, this is what we've done, and the judge kind of said, okay, I'm painted into the corner here, unless I have some indication that continuing this will result in his appearance. We're going to forge ahead. What's wrong with that?
I think the issue is there is a reasonable likelihood that
the issue is what?
There is a reasonable likelihood that the witness could have been secured for trial had the capias been executed. My understanding is the warrant was never entered into the system, so that law enforcement never acted on it. So we don't know.
That's interesting right there, because the capias warrant, which is a civil process.
Yes.
The statute really only says grab him and tell him when to appear. I mean, it's not like they necessarily hold him until, they're not going to hold him without bail until trial.
Correct, but no one ever ended up grabbing him at all.
Do we know now where his whereabouts were during the meantime? Was he out of the state? Was he in jail somewhere? That's the question that's looming in the background here.
I think, to the best of our knowledge, the residence that he was subpoenaed at and served at multiple times would have been the first place to check for his whereabouts. We have no indication that he would be anywhere else.
So we still don't know where he is as of today.
I would assume he's still in the same residence. Our private investigator was able to locate him, so I think the state would be able to do so as well.
I guess I see this as two issues, right? Whether it's an abuse of discretion to continue generally, not to have continued the case generally. But second, it seems that you're alleging a violation of the right to compulsory process.
That's correct.
And as to that second, because I think what is the extent of that right?
It's in both the federal and state constitutions. I'm going to pull up my notes here. So starting with Holmes v. South Carolina, the Constitution guarantees criminal defendants a meaningful opportunity to complete
Okay, so
a defense.
meaningful opportunity to present a defense. You had the access to compulsory process, and you didn't use it for this trial. The state doesn't have to do it for you.
I think the argument here is that the defendant used its mechanism. The defendant's only mechanism is a subpoena to secure a witness for trial. The defendant used that multiple times, to which
The defendant used it once.
that's true. The defense used it once, the state used it twice. Knowing that this individual just kept ignoring the subpoenas. I mean, our office sent him a mileage check that he tendered, that he cashed. So he exists. We know where he is.
Would your abuse of discretion argument be stronger if you had subpoenaed him specifically for this trial?
Probably.
And he didn't appear?
Yes.
So doesn't is the converse also the case, that because you didn't subpoena him for this trial, you had a weaker position on the motion to continue?
I think that's fair. I think the other piece of this is that, again, the defendant tried, and multiple subpoenas went unsuccessful, and at that point, it was this defendant's understanding that this capias had been ordered and that law enforcement would execute it.
Did you say earlier that you did have a PI?
Yes.
And the PI confirmed that he was still living in the same residence?
Our PI was able to serve him, so that would have been back in January, but he was served at the same residence, is my understanding, in July of '24 as well.
But did the PI confirm closer to the time of trial where his whereabouts, where the witness's whereabouts were?
No, at that point, I think the state had subpoenaed him at that residence in November, I think, was the second time the state did.
But they subpoenaed him for the November docket call, not for the December docket
Correct,
call, right?
correct.
You know, on the constitutional point, we flip the narrative and say, yeah, of course she had a right to compulsory process. She used subpoenas, she used capias, warrant of arrest, all that stuff was available at every point. It required follow through, follow up, and the rest of it, but in no time were those processes denied her. Is that a fair statement?
I think that's a fair statement, but I also think a continuance would have allowed for time for those processes to be fully executed in a way that they weren't, so that the capias, the warrant with the capias was never actually entered into a system to allow
At
for
what
law
point did you
enforcement to
find
act
that
on it.
out, that the warrant had not been entered into the court system?
Is that in the record? I don't recall seeing that in the record.
I think the docket record is a little bit unclear about.
And we pulled, by the way, the civil case that had the actual capias in it, because that wasn't provided as part of this appeal, either in the appendix or anywhere else.
I'm sorry, can you repeat your question?
I was just wondering, at what point did the defendant realize that the warrant had not been entered into the system?
My understanding is the day of trial. I know a couple of days prior to trial, defense counsel had reached out to the court to remind the clerks and the trial justice that this issue is still outstanding. We know where he is. This warrant hasn't been executed. What do we do at this point? And to no avail, because he didn't appear for trial the day that,
How
the
many
day of
times
trial.
is this court supposed to continue the case?
I think there's a difference between a continuance and a case not being reached at docket call. I think there was probably some backlog because of COVID in the case.
Fair
And
enough.
this was an older case, so, and I think the state's brief actually articulated better than my brief that the case was not reached. The case was not reached. It's not that the defendant was filing motion to continue after motion to
Fair
continue.
enough, I agree. It's not, there weren't 9 motions to continue from the defendant.
Yes.
I understand that.
And I think, this would be different if we didn't know where he was, or they had executed the warrant and notified him when to go to trial and he still didn't appear. It's that those processes didn't play out to allow the best chance at securing him for trial.
What about the fact that, let's assume we agreed with you that this was an abuse of discretion. What about the fact that she entered a plea rather than going forward with the trial? How do we assess whether it mattered?
That was an effort by the defense not to waste the jury's time, the court's time, the judge's time, when the case simply didn't have any other defense. Had the defendant herself chosen to testify, she would have impeached herself based on her statements made at the scene. The only person who was
Right,
able...
because she said she was the only one driver. that
She
the one
was.
driving.
She was. If she had testified, I think her testimony would be that she went to an event, she had 2 drink tickets, she doesn't remember anything after her first drink, so something happened.
But in terms of a due process violation, i.e. a violation of the right to compulsory process, don't you have to show that it made a difference, that it mattered, that there was prejudice?
Well, I do think it mattered that he wasn't in attendance because he was the only one who could confirm that someone else was driving. Ms. Marichal had no recollection of the night. She had no recollection of her own statements.
But without her on the stand testifying and knowing what she would testify to, isn't it challenging for us to evaluate whether there was actual prejudice? And she may not have testified,
And
but I understand that, but I think we're left with, well, we don't know how much it mattered.
I think Mr. Johnson's testimony was essential to her case and her only defense. And I think that the trial counsel stated that in the colloquy of the plea, that there was no sense going forward and wasting everyone's time when there was no case without him.
When we evaluate prejudice, do we have to accept defense counsel's representation that you would be prejudiced?
No, but I think you could consider it.
Well, what you're saying is the record reflects that this was a crucial witness for your defense.
Yes.
And it's like a sort of an offer of proof. So the fact that this was such a critical witness in itself shows prejudice, correct?
Yes, thank you.
There don't seem to be additional questions. Thank you.
Thank you.
Attorney Mader.
Thank you, Your Honor. May it please the court. The issue before this court is essentially twofold. One, was there a due process violation? And 2, did the trial justice abuse her discretion in denying the motion in limine and denying the request for continuance? I'll address the due process violation first. I would suggest that on this record, there simply is no due process violation. If the court looks at page 8 of the transcript of the colloquy between the court and counsel, the court outlined the requirements under the hearsay rule 804 as to what type of testimony is available.
You're going on the issue of the denial of the motion in limine.
I am, Your Honor.
I don't think that they actually appealed the denial of the motion in limine. I think that they may have realized that the trial justice was correct.
Well, I just wanted to point out to the court that as part of the due process violation allegation, you should look to that analysis that the trial court went through.
Okay.
I would also suggest to this court that there was a procedure available to the defendant should they have chose to avail themselves of it. They could have proceeded and asked the court to issue a material witness warrant under the Maine Bail Code. That material witness warrant would have authorized the actual arrest of the individual, the actual requirement that that individual appear before the court, and the court making a determination as to whether or not bail was appropriate to secure their attendance at trial.
Can I ask you about that, about the subsequent request for a witness subpoena or a witness warrant? And correct me if I'm wrong on this. Apparently, the motion to eliminate was heard on November 25th, 2024, and the judge then signed an order saying that they would issue another arrest warrant for Johnson to appear on December 16th. That was what the court's order said. But apparently the docket entry says, I'm quoting, clerk to tell Oxford Sheriff's Office to try to locate Johnson and PR him to 12/16/2024. But then neither the court file or even in the civil matter contains any warrants of arrest. It sounds like the judge authorized the warrant and then nothing happened afterwards. Can you cast any light on that?
I did not look at the civil file, Your Honor, but my understanding was that the court issued a capias, and the court referred to that on multiple occasions as capias. And as this court is aware, a capias does not authorize the physical arrest of an individual. It just authorizes the executing law enforcement agency to inform the individual of their requirement to appear in court. There is a specific provision in the bail code that authorizes a court to issue an arrest warrant for a material witness, and actually authorizes the court if it makes the
That's
appropriate...
what I'm wondering, whether that, what happened on the 25th, was that just, oh, we'll try another capias, or was it an actual arrest warrant to get him there on the day in particular?
I don't know the answer to that question, Your Honor. The request that was made by defense counsel was not phrased in terms of the bail code and a material witness arrest warrant. The phraseology was that of a capias. So what I'd like to point out to the court on the allegation of a due process violation, there was a process available to the defendant that they apparently chose not to execute. That process would have authorized an actual arrest warrant and bringing the individual before the court to make a determination as to whether they should be held without bail or admitted to bail to ensure their appearance at trial.
Got it, and that's why I asked. I didn't know what exactly happened on the 25th, whether it's just a capias request again, or whether it was a material witness warrant that was being requested, but you're saying you don't think it was the latter.
I don't believe it was the latter, Your Honor.
It seemed like it was a bit unclear, but the original request was pursuant to a civil statute, and that's what seemed to be pursued.
That's correct, Your Honor. There was never any documents filed that I was aware of that made the request for a material witness arrest warrant. Okay. On the issue as to the court's denial of the continuance, as this court has said on multiple occasions, that decision is left to the good discretion of the trial court. And in this particular instance, the trial court did put significant information on the record as to why they were denying the continuance. And I know that the court has reviewed the briefs. I did try to outline in my brief the number of occasions that this matter was actually before the court. I will just highlight a few. The allegation occurred on or about October the 1st of 2021. The defendant was arraigned on 11/24 of 2021. There were dispo conferences scheduled in May and August of 2022. The first time it appeared on a docket call was on November the 30th of 22. There were multiple other docket calls. For some reason, it was sent back for another dispo on May the 18th of 2023. I believe that was during the blitz, so-called blitz in Androscoggin County. I believe that's why it was sent back for another dispo. And then it appeared for docket call after docket call after docket call. Some of those, it was not reached for trial. Some of those
Did the defendant ever ask for a continuance?
I don't believe the state ever requested a continuance.
No, the defendant. Did the defendant ever move for a continuance except on this one occasion?
There was at least two requests, the one on the last docket call and then one prior to that for a continuance request for the inability to secure the the civilian witness that they were attempting to bring into court. From the state's perspective, Your Honor, there is simply no due process violation. The court did what it was asked by defense to do. It issued a capias. Defense produced nothing on the record to show what efforts were made to make sure that that order of the court was appropriately acted upon by law enforcement. In fact, it was the court, if you review the record, who actually made the call to Oxford County because the recalcitrant witness was living in Oxford County. It was the court who made the call to the clerk's office in Oxford County to make sure that the capias had in fact been appropriately sent to the Oxford County Sheriff's Office. There was a procedure designed specifically for this particular sort of an event that defense counsel did not avail themselves of. On the issue of the denial of the continuance request, the holdings of this court previously are very clear. This is an abuse of discretion review. And in this particular instance, the record is...
Do you think it would be an abuse of discretion had the defendant subpoenaed him for that day and he didn't, let's say, successfully, and he did not show? Do you think that would be an abuse of discretion to deny the continuance?
I would suggest, Your Honor, that if in fact a properly issued subpoena had been served and the defendant chose to ignore that subpoena and that information was brought forth to the trial justice, then yes, the trial justice could have exercised authority to request that an arrest warrant issue and the properly subpoenaed witness be brought before this court. But in this case, the witness...
My question was, would it be an abuse of discretion to refuse to continue it had that been the case, i.e. I subpoenaed a witness, he's not here, he's disobeying a subpoena?
I think the defense argument would be significantly stronger on if that was the factual predicate in this case, because at that point the defense had done what they needed to do to secure that witness. They were properly subpoenaed for the date and location and time in question and apparently ignored that subpoena. In this instance, that event did not happen. And from the state's perspective, Your Honor, there simply is no due process violation, and the trial court did not abuse its discretion in denying the request for the continuance and did not abuse its discretion in denying the motion in limine. And if the court has, I have nothing.
It's my understanding, and correct me if I'm wrong, that the state actually subpoenaed this guy for the December date?
Yes, Your Honor.
For the December date or for the November date?
The November date. We had the witness under subpoena on at least 2 occasions, Your Honor. My office never had any contact with the witness, and I did provide that information to the court. It is in the transcript. The witness never responded to us. My intent...
The note I had said that the state subpoenaed him twice, on July 15th for the August 24th list and on December 6th for the December 2024 list. Right? Am I wrong on that? I've got a
Not, if that's in the record, Your Honor, then that would be the information that was before the court.
Okay, well, I'll double check that. I've got a reference to Appendix 21 to 24, transcript 9 through 11. And hypothetically, if the state did subpoena him for that date, can the defendant sort of pull that in and say, well, they subpoenaed him and he didn't appear, and therefore sort of ride along on your subpoena, if in fact that's what happened?
I think a subpoena is a subpoena. It authorizes, it requires an individual to appear. From my perspective, my intent was always to try this case with just the 2 law enforcement officers. The evidence from the law enforcement officers and the statements from the defendant's own mouth, 100% I was driving, and the law enforcement officers were astute enough to look into the vehicle, even with that statement, and to see that the passenger seat of the vehicle was pulled significantly forward, thereby creating an inference that simply no one would have been sitting in that seat. So from the state's perspective, there is no due process violation based on the record before this court, and the trial justice simply did not abuse her discretion in the rulings that she entered that are currently before this court for review.
There don't appear to be additional questions. Thank you.
Thank you, Your Honor.
You reserved a couple minutes for rebuttal.
Yes, thank you. I'm now looking at appendix, the subpoena that was served by the state,
Yeah, it was for December 9 through 18.
which would include December 16th. So I think there's an argument to be made that he was subpoenaed for trial and simply did not appear, which was expected based on his several failures to appear.
Wasn't
before
subpoenaed
that.
by you, but was subpoenaed by the
It was by the state. I think at that point, the defense is a very unique situation. It's not something that I think trial counsel ran into before.
What about the argument that you basically followed the wrong process, which I kind of pointed out to you earlier, that the KPS isn't going to, they're not going to hold him and bring him to court when you need him?
I mean, unfortunately, that would have been great had that happened, but it didn't. So we were left with waiting for the KPS to be executed so that we could.
But I mean, it's the defense that asked the court to issue a warrant, and I think what Attorney Mader was basically saying is, you did it wrong. Have you thought about that at all? If you haven't, you can just say so.
I haven't until right now. I think that's a fair argument, but I also think, going back, he was subpoenaed to be there the 9th through the 18th. He didn't appear at all. That was the third time he had been subpoenaed and not appeared. And
But isn't that a basis for changing if it's not working, then you need to move on to something else?
I think those efforts were the KPS because, and I acknowledge that may not have been the best solution, but that was the solution that trial counsel went with.
Well, I will say that I did puzzle over that a bit, having seen many KPSs and how effective they really aren't.
I think it's a tool defense counsel had not had to use before.
Okay.
So I just want to conclude with that. He was subpoenaed to be there on December 16th. He did not appear multiple times. The KPS was not executed. A continuance would have allowed more time for the KPS to be executed to see if it worked. We don't know if it would work or not because it wasn't executed.
Thank you. Thank you, counsel, for your arguments in this case. As we ordinarily do, we will take the matter under advisement and issue a written decision in due course. Attorney Casey, it's my understanding this is your first time before the court. I'm pretty sure it's not Ms. Mader's first time, but we would invite counsel back to take the greetings of the court.
All rise.
Good morning, you can be seated. The matter before the court is VCD 24481, in re the Mount Desert Island Hospital Data Security Incident Litigation. We are being streamed on the web, both by audio and by video. I see counsel are present. I'm assuming ready to proceed. I would ask that counsel introduce themselves for the record together with the party you represent, starting with the appellant.
Good morning, Your Honor. David Leitz with Peter Murray for the appellants.
Good morning, Your Honor. Nellie Fitzpatrick on behalf of Mount Desert Island Hospital and on behalf of the appellee. I'm joined here by our local counsel, Brendan O'Brien.
Thank you. And counsel, if you're ready to proceed, we'd be happy to hear your argument this morning.
Thank you, Your Honor. May it please the court. This case implicates the bedrock principle that Maine trial courts are courts of general jurisdiction, not limited jurisdiction. And unlike the federal courts, the doors to Maine trial courts are open to any litigant who, quote, asserts a personal stake in the outcome of the litigation and presents a real and substantial controversy touching on the legal relations of parties with adverse legal interests. The burden on standing in Maine state courts is not high, according to this court's ruling in Roop versus City of Belfast, which says the standing threshold is minimal. And generally, state courts, like the Maine trial courts, only deny standing in cases where private litigants are attempting to assert public rights. Those are the standing cases at the state trial courts that tend to fail. But that's not this case. Here you have private litigants who are trying to assert their own personal tort and contract rights arising out of this data breach. That's a different case. And it's certainly a case, Your Honor, where the litigants have the requisite personal stake.
Counsel, I see that the green light is on. I'm going to maybe save you some time or maybe move you to something else. Let's assume that in state courts, standing is first prudential rather than jurisdictional,
Yes.
and that certainly your clients have alleged that they are different than the public at large in the sense that there was a data breach that didn't, this particular data breach, although I don't know that there's anybody that hasn't been the subject of a data breach, but this particular one didn't affect everybody. Did the judge below decide this case on the basis of standing, or is it a 12b6? Is the issue here whether there is a recognizable, compensable injury?
It's plainly a standing ruling, Your Honor, and we know that because of the way in which the
Funny, I didn't interpret it that way until I started reading the briefs.
So I think the key, Your Honor, is how the trial court handled the inferences. So the trial court made specific reference to the 12b1 standard of not taking all inferences in favor of the plaintiffs because it was a standing analysis. And if it was a 12b6 analysis, Your Honor, that would be the opposite.
And if it's a 12b6, it's permitted to be dismissed with prejudice?
It could be. There's different options with 12b6. So the court could, allow in its discretion a dismissal without prejudice with some leave to replead, even if that wasn't specifically requested by the litigants. The court could say, as a matter of law, that the case would be dismissed with prejudice. But again, what we have here is unmistakably, because of the way the trial court handled the inferences, a standing ruling. I think another...
So you don't want us to go into the issue of whether these damages that have been alleged are compensable under Maine law. You just want an order that says they have standing without a lot of discussion, except to say it's minimal, and send it back for a 12b6?
Yes, Your Honor, I think that's the correct course of action. It's the course of action that the First Circuit Court of Appeals took in the Webb versus Injured Workers Pharmacy case. And I think that the trial court is better situated to evaluate the 12b6 questions.
Well, let's take a look at that. Let's take a look at that for a moment. Are there any, as pled in the complaint, are there any damages sought other than damages for risk of potential injury?
Yes, Your Honor.
And what are they, and who do they pertain to?
So all of the plaintiffs assert that they suffered damages in terms of the loss of the benefit of the bargain.
What does that even mean, benefit of the bargain?
So the benefit of the bargain is that there's a contract claim in this case, and the question is, did the plaintiffs get what they bargained for?
What did they bargain for?
They bargained for medical care with data security. No reasonable person would turn over their private protected health information and personally identifiable information to a health facility that didn't assure them that they would have reasonable...
Well, they might if they wanted to be treated.
If they wanted to be treated, yes, it is a requirement, and that sort of compulsory turning over of the information sort of exacerbates the problem. It becomes necessary for people to get basic health care, to give over your PHI and your PII. That makes it more important that a facility like Mount Desert would
But if you're
protect.
saying, and you did allege, that there's an explicit contract that covers the issue of your data security, and if your damages are purely economic, then you got a problem under the economic loss doctrine, don't you?
No, Your Honor. So I think the economic loss doctrine is going to really apply for the negligence claims, the tort
Right.
claims. I think under Maine law, the economic loss doctrine is really sort of an election of remedies, and it basically is articulating the principle that you can't claim contract damages and then turn around and claim tort damages.
Right, so are you precluded from asserting the tort claim here if there's a contract?
Well, we're at the pleading stage, Your Honor, so we can plead in the alternative. We don't know which is going to prevail, the contract claims or the tort claims. The defendant has denied, in terms of their response to their motion to dismiss arguments, they have denied that the contract actually does provide for data security. There's fact questions bound up in this, and also the whole question of damages at this stage is more about whether or not the damages are available, not whether or not there actually are damages. And this court recently...
But it is fair to talk about what the nature of, I agree with you that it's not whether they actually, or to the extent to which they were damaged, but there does have to be an allegation that they were damaged in a way that is legally compensable or cognizable for that claim.
That's right, Your Honor, and under Maine law, being put back in the position that you bargained for is compensable damages, as we pointed out in our brief. So the benefit of the bargain. We also, just on nominal damages, which are available under Maine law, under the Baker versus Ferran case, which is 26A 3rd 806, nominal damages is pled 5 or 6 times in the complaint. And, one of the big data breach cases that was recently certified down in the District of Columbia let the breach of contract claim proceed on strictly a nominal damages model.
Can you talk briefly about the substantial risk of future harm alone, whether or not that has wings on it to get you past the standing door, saying something happened and that something could result in something significant down the road? Is there a missing link in that chain?
No, Your Honor. So again, standing is a minimal burden, and it's whether an injury, cognizable injury for standing purposes, is a different concept than cognizable injury for damages. And that's sort of the distinction of Hannaford. So Hannaford is a case that isn't looking at cognizable injury for standing purposes at all. It is referred specifically to this court for the question of whether or not time spent is damages. So you use that term, cognizable injury, but you're really talking about damages.
That's why I actually was using the term compensable injury.
Right, yeah. And maybe that's a better term, Your Honor, but what we're talking about in terms of injury for opening the doors to the courthouse, which is really fundamentally what this appeal is about and what this case is
Well,
about.
I still want to back up and say, but why can't we simply, if we agree with you that standing's not the issue in this case.
Yes.
But if we believe that the complaint fails to state a claim upon which relief can be granted under 12b-6, why can we not affirm on that basis?
You could,
Or
Your
why
Honor.
should we not affirm on that basis?
You could, Your Honor. You review this whole issue on a de novo standard, so it's certainly within the purview of this court to evaluate the claims, the sufficiency of the legal claims on a 12b-6 standard.
Which was part of the motion. I mean, it was a motion on 12b-6 as well as 12b-1.
That's right, Your Honor. But again, I think that what you're doing here is evaluating the trial court's ruling, which again is a standing ruling, unmistakably. All the discussion of TransUnion, which is standing, all of the inferences standing.
Except the dismissal was with prejudice. Isn't
Well,
that
right.
an adjudication on the merits?
It is, and you know, that's erroneous because, again, under Maine case law, if it's a standing dismissal, it has to be without prejudice. The case law is clear about that, and the trial court clearly erred in dismissing it with prejudice on a standing basis. But turning back to sort of the injury for purposes of standing, you know, it's a lower standard. The kind of injury you need to show to open the doors to the courthouse can be a different sort of kind of injury. And one of them is this imminent risk of harm. And, you know, basically this is where sort of this three commonality test, which is a very commonsensical analysis, comes into play. How do you address the question? And the Maine trial courts or the Maine law court have not really sort of looked at the question
Well,
yet.
what's missing from the record to make it inappropriate for us to look at whether this states a claim?
What's missing from the record yet is nothing, except that if the hole in the plaintiff's case is damages, then the trial court and this court would be making a mistake to sort of determine the damages issue on the merits at this pleading stage.
So you're saying not so much that we can't decide whether this states a claim, but that it's more appropriate to determine whether there are compensable damages at the summary judgment stage.
You seem to be saying it's really a fact issue.
It is a fact issue.
What are the facts?
But,
Yeah.
but does that mean it's adequately pled?
If the four corners of the complaint basically say, something happened, I was in a...
You're getting frustrated, we're not allowing you to.
I'm sorry, did you want to answer? I didn't mean to cut you off.
No.
I was going to steer you, I think, to the point you may be making, but I was going to ask if the four corners of the complaint allege something happened, it was the car slammed on its brakes right in front of me, didn't hit me, but I have a serious risk of PTSD coming down the road afterwards. And there's some support for that. Does that get you in the door to say something happened, and because of that, I feel that I have a risk of something else happening to me?
I think in that hypothetical question, Your Honor, the answer would be no, but that's not what the complaint alleges here. So if you just focus in on one of the damages allegations, you know, for purposes of sort of getting past a 12b6 motion, it's the question of the fraudulent charges. So there's a fact question there, and the judge basically, this is where the whole inferences thing comes in. The trial judge basically said, I'm not going to assume, even though your complaint is silent about whether or not these charges were reimbursed or not, I'm not going to assume that they're unreimbursed. In fact, I'm going to take the inference the opposite way, and I'm going to assume reimbursed.
And I agree that's appropriate, maybe appropriate under 12b1 and not 12b6. However, isn't it fair to say that even under a 12b6, you have to allege you were actually damaged as opposed to just leaving it up in the air?
We do. There's the allegation.
On that issue of the unreimbursed charges.
Right.
So it's not a burden or an inference issue, it's not alleged that you were damaged by that.
No, I think that we did allege that we suffered monetary damages as a consequence of this breach. There are broad damages allegations in multiple places that include, you know, the claims that we have suffered, the plaintiffs have suffered, you know, compensatory damages.
I could be mistaken, but my only recollection of a specific assertion of economic damages is with respect to out-of-pocket expenses for time and effort spent in mitigation, which Hannaford, of course, eliminates from the case. But other than that, it seems to me, as I read the complaint, all of the damages are sort of expressed in terms of the potential for future injury.
I see my time is up, if I may answer the question, Your Honor. In paragraph 181, there's a laundry list of the damages, and basically it's more extensive than that, and it's loss of benefit of the bargain, it's the diminution of value, which there's also specific allegations from each one of the plaintiffs about the diminution of value. It's the emotional distress damages, it's the nominal damages. The complaint is replete with other allegations of damages beyond simply the time spent. The time spent was merely one. And the only reason we focused on time spent is because of the question of whether or not the imminent risk of harm qualified as an injury to sort of open the doors to the courthouse and to establish standing.
Can I, because I'm the chief, I get to keep blowing through the red light.
Yes, Your Honor, you can keep me as long as you want.
On paragraph 181, though, the problem is, it says they have suffered or are at increased risk of suffering. And, I mean, that may need to be an election.
Again, Your Honor, I think at the pleading stage where we're doing notice pleading,
Well, what if we decide it's not enough to say that they're in increased risk of suffering, any of that?
I think that...
They have to have actually suffered.
Yeah, and I think with the way it's pled, it is saying we have suffered or will suffer. So it's in the alternative at the pleading stage, which is appropriate. I think that the delving down into the damages question is really more appropriate later on in the case. And we just saw this in the Capital City Renewables versus Peel case that this court decided just this May, 335A3rd 588, where the issue of damages gets decided at the summary judgment phase. There's no question here that the complaint alleges that the plaintiff suffered damages and actual damages. It does allege that, and at this stage, we're just at the pleading stage, that's enough. We get past the low bar. Even 12b-6 is, courts are loath to sort of throw cases out just based on the pleadings, particularly in a notice pleading jurisdiction like this, where in a way we could have just come in and said, hey, there was a contract for data security, that contract was breached, and we suffered damages. If the complaint said those three things, it probably would have passed muster under a notice pleading jurisdiction.
Thank you, counsel.
Thank you, Your Honor.
Attorney Fitzpatrick.
Thank you. Good morning, Your Honors. Nellie Fitzpatrick, may it please the court. Before this court are really, I'd like to make 2 points. First is that the Business and Consumer Court did not err as a matter of law in applying this court's precedent and Maine law in finding that there were insufficient injuries to submit the case past a motion to dismiss. Further, the law in Maine here requires an actual injury for there to be sufficient pleadings. Counsel and the court has rightly looked into the issue of damages, but the pleadings must have sufficient factual allegations to establish that damages exist in the first place. That's really what's at issue here. In applying Maine law and Maine precedent, both in Hannaford and looking at other similar cases, for instance, the cases involving asbestos, the mere exposure or possibility to future harm is not enough. Here, factually, looking at the ruling in Hannaford, Hannaford required the knowledge that somebody had suffered an economic injury. Maine law requires physical injury, economic loss, or identity theft. None of those are present here. And the complaint does not allege that any of those are present here. Instead, the complaint is silent as to whether or not there is an economic injury. That is a problem that the lower court rightly addressed and rightly identified. For that reason, the court, amongst others, dismissed the case, and rightfully so, and we would ask you to affirm. In looking at whether or not it was dismissed with prejudice appropriately, and looking at standing versus whether or not it was for failure to state a claim under B6. For that purpose, Your Honor, when you read the opinion itself, it says all claims are dismissed with prejudice. It does not say that the complaint is dismissed for lack of standing only. It clearly does address both dismissing claims and addressing that plaintiffs lack standing. For that reason, we would also argue that the dismissal with prejudice was not an error of law.
You just said something in your opening remarks that is the issue that what they've done here is maybe allege an economic injury, but as opposed to an economic loss. That seemed to be a distinction you were drawing. Is that a difference?
No, Your Honor.
Okay. So you're not so wedded into the idea that the decision below was on standing grounds only?
No, Your Honor.
And is there a reason why we should not be addressing it under 12b-6 if we think that that's the appropriate mechanism?
No, Your Honor.
So under existing Maine law, did the hospital owe a duty to protect this information? And if so, was that duty contractual or was it imposed under our tort law?
We would argue that it's imposed under tort law if there is a duty. We stand by that a plaintiff's complaint does not allege a contract was formed. There was no meeting of the minds as to data security to prevent a criminal cyber attack.
Well, but isn't counsel for the plaintiff's point well taken? I was sort of joking about that with my colleagues earlier as an old tort lawyer. I mean, we always just said, I was hurt, it's your fault, give me the money. I mean, do I really
Well,
have
that's
to
the
say
issue right
anything
there,
else than that?
is alleging, what is sufficient to allege that you were hurt? That is
That's
the
my
issue.
point. Isn't that a cognizable complaint right there that you can't dismiss? I was hurt, it's your fault, give me the money.
No, Your Honor.
Why?
Because under Maine law, it requires that there be an actual concrete injury.
For relief, yes, but at the pleading stage, it's a fairly generous standard, isn't it?
It is a generous standard, yes.
And
It is a notice pleading
I'd like to
state.
come back to your point about standing. The court does say expressly, the complaint fails to allege facts sufficient to establish actual injury for standing on all counts. I mean, I understand the court goes on to discuss claim and 12b-6 and dismisses with prejudice, but that seems like a pretty clear statement that the court is addressing standing, doesn't it?
Yes, Your Honor, and we would argue that it is not an error of law, that the court did not specifically identify with bulleted numbers, I'm making this decision under 12b-1, I'm making this decision under 12b-6, where it is clear that both 12b-1 and 12b-6 were grounds that were moved for dismissal, that the court granted the motion in its entirety and did not carve out anything saying that this is granted only on 12b-1's grounds. And
But I hear from your answer, an earlier answer to the Chief's questions, that even if the decision was a standing decision, you don't have any issue with us ruling as an alternative ground on a 12b-6, whether it states a claim.
No, Your Honor.
And what you're saying is a part of stating a claim is alleging compensable damages. And so it isn't enough to say, something happened to me, I was injured, I'm hurt, give me money. You need a little bit more than that?
Correct, Your Honor, and I think looking at the subject matter of this particular case, quite frankly, what is before this court and what plaintiffs are asking is that anybody who receives a notification that their information was potentially involved in a data security incident that may involve them and may involve certain data points, that unto itself is sufficient. That you can hold that card up and say, I have been injured, give me money.
What if it did say, instead of have suffered or at risk of suffering, if it just said they have suffered loss of opportunity to control how their PII is used, diminution in value, compromise and continuing publication, out-of-pocket costs associated with prevention, et cetera, putting aside whether they can prevail ultimately on the facts on liability, isn't that a sufficient allegation of a compensable loss?
No, Your Honor,
Why
and
not?
we would argue that first and foremost, Hannaford is controlling. It is the law
It
of,
says out-of-pocket costs.
Your Honor, out-of-pocket costs, though, go to mitigation, and there has been no allegation here that there is an economic loss that justifies those out-of-pocket costs to mitigate any of that harm. So I believe that those words are actually part of counsel's mitigation pleadings and an argument that out-of-pocket costs are going to prevent future harm that plaintiffs say that they are facing as a result of this data security incident.
The plaintiffs argue that Hannaford is not controlling for a variety of reasons, among them that the nature of the breach there was different in kind from the nature of the breach here. In other words, that practically there's a significant difference between having your credit card information breached and your personally identifying information, your personal health information. So why do you contend, despite sort of those different factual scenarios, that we are governed by Hannaford in this case?
Your Honor, when you look at the information in Hannaford, yes, it was credit card information, but that specific information was misused. It was directly, charges were directly incurred by those plaintiffs, And the one plaintiff that alleged that they weren't reimbursed and they suffered an economic loss, that was sufficient for an injury. Here, there's no allegation that the unauthorized charges by the one plaintiff, Plaintiff Gorell, there's no allegations that those credit cards, LL Bean specifically, were actually even in the possession of Mount Desert Island Hospital. I believe that there's a real causation issue that we would point the court to there.
Is that a fact question?
No, Your Honor.
In other words, you may very well win on summary judgment. I'm not suggesting that you might not, but the question is it adequately pled to allow it to get past the 12b-6? And we don't resolve any fact questions.
Yes, Your Honor. And here we would argue that it is not, that there are no allegations of physical injury, of economic loss, or of actual identity theft.
Wait, can I put you in perhaps a difficult position? I'll make this an optional question.
Absolutely.
You can answer and not if you don't. What would a plaintiff who has suffered a data breach loss of PII have to allege to make it adequate to pass through the standing door? In other words, put a plaintiff's hat on for a moment and tell us what you think would actually fly. And that's an optional question because I realize that's not the point you're arguing here today.
Yes, Your Honor. I think that there's multiple facets to that question. And so to avoid going down each part of where I think the pleadings are insufficient here or where we would submit the pleadings are insufficient here, if you're looking first and foremost at whether or not there is economic loss, so step one, perhaps arguendo, if Plaintiff Grinnell, who I believe is the one that submitted that her cards were unused without her authorization, if she had pled that those charges were not reimbursed, that reversal and reimbursement was denied, and that she suffered an economic loss, perhaps that would be sufficient.
If somebody has to hire a lawyer to undo a false income tax return, that's an out-of-pocket expense?
Perhaps, but that is not the case here. In an attempted tax return, which there is case law that an argument in the briefs that are submitted, an attempted tax return in many ways is self-defeating, and it points straight to Hannaford because there was no economic harm if it was attempted and never came to fruition. So perhaps, Your Honor, that would be a factual circumstance that might give rise to sufficient pleadings to survive a motion to dismiss.
And stepping back to the issue of duty, should we take anything from the fact that the legislature has stepped in to impose a duty to disclose, but hasn't said anything about any duty beyond that? And in other states, legislatures have stepped in beyond that to outline what sort of duties arise in data breach situations.
Yes, Your Honor. I believe that starts to venture into a very important policy discussion that is housed both in courts as well as in legislatures. As this particular part of our human lives continues to develop, this is something that laws are going to have to be developed to deal with. Quite frankly, as legislators are looking at that, they also need to grapple with there have to be some level of safe harbor and protection for entities like a nonprofit hospital off the coast of Maine that if they are
Judicial branches. Judicial branches.
Correct, Your Honor. Judicial branches, the Department of Justice, perhaps. These are cyber attacks by often state-sanctioned terrorists that are occurring. So, for instance, Mount Desert Island Hospital, in a world in which we get to where there is proper legislation, there should be a safe harbor that protects them from an onslaught of class action litigation from individuals who received a notice in the mail that they potentially were involved in yet another data security incident. As the court keenly commented earlier, I'm not sure that any of us here have not been subject or somehow notified that we might have been involved in a data security incident.
But those big ticket policy issues,
correct.
That's not our
exactly.
department.
And so pointing to the law of Maine, which is controlling and which is directly on point here when it comes to what is a sufficient injury of a compensable injury for purposes of a sufficient pleading, here we would submit that it is not.
Since standing is a prudential exercise and not a jurisdictional exercise, would that be a sufficient reason for the court to not get involved in these kinds of cases and say this is a legislative issue? It's a bigger policy question?
I think, no, Your Honor, because I think the law of Maine as it is sufficient and can take care of these issues at this point. It is well-reasoned to look forward and to grapple with what is necessary to identify these issues in terms of layering in legislation. However, the law of Maine is up to the task of determining whether or not there is a compensable injury here as pled.
Yeah, but the question is, at what stage of the process is that? Is it at the pleading stage? Is it at summary judgment? Do these cases go to trial? And in the meantime, you have massive litigation efforts going on. So my question comes back to this. As a prudential matter, could the court consider that this is a legislative question involving broad policy issues, weighing of risks, and say, we're going to find it in the context of this case where the damages alleged are pretty speculative, that we're going to find no standing?
Your Honor, I believe that you could find no standing for those reasons because they are speculative, yes.
We don't expand our existing tort law when it comes to a duty on a part of a defendant to protect against third-party malfeasance very generously under our common law. So is this covered under our existing law about which people are liable for third-party malfeasance, or are we getting into new territory of a new duty?
Your Honor, we believe that Maine law does cover this and that this is sufficient when you are looking at those types of allegations. So
you're saying you did owe a duty?
No, Your Honor.
Okay.
Yeah.
No, I'm not sure I understand. I'm not sure I understand the question. I apologize, Your Honor.
I mean, I'm saying, what is our existing common law about the duty of somebody like a hospital to protect against third-party malfeasance? Does it cover this? So you have a duty under existing Maine law?
I understand, Your Honor. I understand. No, Your Honor.
Okay.
I apologize. I think I had a double negative in perhaps the way I was hearing.
Okay. Well.
Are you okay?
I am. He said no. We're done.
All right. Thank you. Thank you,
Thank you, Your Honors.
Now, you want to explain why there is a duty? That would
And Mr. Cleaves, I think you've reserved a couple of minutes for rebuttal. That might be a place to start.
Counsel, let me come back. Let me ask you that same question, if I may. You say in your reply brief that an overarching theme throughout this matter is the question of allocations of risks and duties in a modern information-based society is lurking in the background.
Yes, Your Honor.
Again, why isn't this an appropriate topic for the legislature to take up rather than this court, particularly on the basis of the pleadings here, where it appears to be, for the most part, the injuries alleged are future-oriented?
The question of what constitutes a legally cognizable injury is a question of law for the court. It's not a legislative question at all. So that would be why it is inappropriate for the legislature to take this up. I think we have to return to the focus here, and Your Honor, you kind of put your finger on that heading number 1, which is the only heading in the trial court's ruling, which plainly says the complaint fails to allege facts sufficient to establish actual injury for standing on all counts. This is a standing decision. This court, if you want to spend your time on big issues, which are not policy issues, you should articulate once and for all the standard for standing in a court of general jurisdiction.
So what's your best case for our existing common law creating a duty on the part of the hospital to protect against third-party malfeasance? What's the best Maine common law on that duty?
There wouldn't be, but you don't need to do that, Your Honor. You don't need to sort of articulate some broad new right that there is a common law right to privacy. These claims exist in all jurisdictions all over the country without there being any form of common law right to privacy. And the duties derive from different sort of sources, including contract, including things like the mini FTC statutes, so the Maine Consumer Protection Act, and the relationship between the parties, the special relationship that these people have between themselves and the healthcare providers, basic principles of foreseeability. You don't need to do that. But if you did want to do it, you could follow the decision in the Aon case out of Illinois, which I don't think I have the site for, but it's one of our cases. And basically, in that case, an intermediate appellate court in Illinois said that there is such a duty under Illinois law when one hadn't been recognized before for privacy purposes. And you could follow sort of the lead of the Aon court.
Thank you, counsel.
Thank you, Your Honor.
And thank you. Welcome to Maine, since both of you are here pro hac. And hopefully the experience was all right. With that, we'll be in recess on this matter. You may be seated. The matter before the court is State of Maine versus Keith Merchant, which is Somerset 24-439. This is a sentence review panel matter, so it's actually SRP number, sorry. And it appears counsel are present, and we are being streamed live on the web, both by audio and by video. And if counsel are ready to proceed, I'd be happy to have you introduce yourselves for the record together with the party you represent.
Good morning, Your Honor. Jack Baldacci for the appellant, Keith Merchant.
Your Honor, Michael Madigan for the State of Maine.
And Attorney Baldacci, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you, Your Honor. Good morning, Your Honors. My name is John Baldacci Jr., and I represent Keith Merchant in this appeal from a 30-year unsuspended sentence imposed by the Somerset County Unified Criminal Court following his guilty plea to 8 counts, including 2 Class A gross sexual assaults. The sentence must be vacated due to fundamental errors in the court's Huey analysis and its gross disproportionality under the Maine Constitution. First, the court violated Mr. Merchant's double jeopardy protections by conflating conduct from counts 1 and 3 when setting an 18-year basic sentence on count 1. Despite an indictment spanning only 1 year and 10 months across all counts from October 1st, 2021 to July 31st, 2023, the lead detective testified to offenses over 3 to 4 years. The prosecutor argued, quote, 3 years of abuse, and the court cited conduct, quote, over a period of a number of years as an enormous aggravating factor, explicitly relying on, quote, as Detective Leal testified. Even the court's subsequent clarification attributed 1 year to count 1's 5-month time frame, punishing Mr. Merchant twice for overlapping acts, contrary to State versus Armstrong. Second, the court failed to follow State versus Stanislaw in deciding each count in a vacuum by finalizing a 20-year unsuspended sentence for count 1 before resolving consecutiveness for count 3. This fragmented approach prejudiced Mr. Merchant by preventing holistic adjustment of the aggregate 30-year term, abusing its discretion, and undermining mandates for individualized sentencing and rehabilitation. Finally, the 30-year unsuspended sentence raises an inference of gross disproportionality under Article 1, Section 9, and Stanislaw's test, exceeding murder's 25-year minimum while unevaluating mitigating factors like substance abuse addiction, childhood sexual abuse, and brain injuries. It dwarfs sentences in comparable cases involving similar offenses, such as those with multiple incidents or younger ages, receiving significantly lighter unsuspended terms. We urge this court to vacate and remand for resentencing consistent with Huey, Stanislaw, and constitutional principles. I welcome your questions.
In this case, the court did a Huey analysis on count 1, arriving at a basic sentence of 18 years and with aggravating factors, a maximum sentence of 20 years, right?
Yes, Your Honor.
Did the court engage in a Huey analysis on count 3?
It engaged in a Huey analysis on count 3 and incorporated the same conduct.
If it's the same conduct and the same analysis, why is the sentence 10 years on count 3 and 20 years on count 1?
Your Honor, I believe that's a question for the trial court.
Well, or is it a legal question? In other words, if it's the same Huey analysis, isn't it supposed to be the same sentence on the same charge?
Well, Your Honor, for consecutive sentences, the court's supposed to individualize sentences. And so the court on count 1 had an indictment.
So putting aside the consecutive nature of the sentences, I'm trying to figure out whether it's appropriate at all for the court to put 20 years on count 1 and 10 years on count 3 if it is saying, and I believe that's what it says at page 44 to 45 of the sentencing transcript, the court's general sentencing conclusions reached in arriving at the sentence in count 1 also apply to count 3. And yet, They're two entirely different sentences.
Well, Your Honor, I believe...
Is that a problem? This is a softball question.
Thank you, Your Honor. We believe it stems from an error in the sequencing, where the court...
You can just say, yes, it's a problem.
It's a problem, Your Honor.
It's a big problem, isn't it? To say, here's the analysis, I arrive at 20, I'm using the same analysis, it's 10.
And we think that's where the sequencing issue went wrong, where the court did a fragmented approach and then tried to remedy it at the end, where it set a overly harsh sentence on count 1 and then went into sentencing on count 3 and tried to lighten the sentence by imposing a lesser sentence. This is why we feel our second issue, the sequencing issue.
But can I probe that a little bit? If the court determined that a 20-year sentence was appropriate on count 1, how does going to phase 3 in the Huey analysis on count 1 provide an opportunity to temper that?
Well, Your Honor, I think the court's mandate in Stanislaw is to take a more holistic approach.
No, I understand, but the court's already designated or determined that 20 years is the maximum sentence. The purpose of the count of phase 3 in a Huey analysis determined how much of any of that should be suspended. But that really wasn't an option, was it? Because A, there's going to be supervised release, and B, that would be an illegal sentence if he imposed a split sentence on count 1 and then came in with a consecutive sentence on count 3.
Your Honor, I believe the court explicitly stated that in our view, it had a flawed analysis by going to that step 3 of the Huey analysis before deciding on consecutive sentencing, because it said after going through the first 2 steps on count 1, it finalized its analysis by saying we are not going to, the court's not going to suspend any portion of the sentence because there's an availability of supervised release. But supervised release, the court only attached it to count 3. And
Well,
so,
it would have been illegal to attach it to count 1 and then do a consecutive sentence in count 3, right?
I believe so, Your Honor.
Can't we infer that the court had made the decision about consecutive versus concurrent? In other words, the court says at the outset, these need to be consecutive, or excuse me, I have to consider whether they're consecutive. Doesn't then say one way or the other, but then engages in a separate analysis of count 1, separate analysis of count 3. If the court had determined they were going to be concurrent, it wouldn't need to do separate analyses, right, on count 1 and 3. So can't we infer from sort of the way the court did the analysis that it had made the decision at the
And
outset?
it specifically referenced it was going to do a supervised release on count 3. So, I mean, the court is really telling you, I've made an analysis that it's going to be consecutive.
Your Honor, I think we would submit that the court wasn't clear that it had made the decision on consecutive sentencing, and that the admonition in Stanislaw is the court needs to decide and not just reference whether it's going to impose a consecutive sentence. We believe the fundamental error here was the court treated both counts as in a vacuum analysis and failed to provide a holistic sentence.
Well, doesn't the state concede in its brief that it's unclear that the court had made that determination at that point?
Yes, Your Honor.
You had, I believe, raised as an issue here that in sentencing on count 3, the court apparently said count 1 involves multiple incidents over the course of 1 year, and count 3 involves multiple incidents over the course of another year. And in fact, as we know, count 1 was actually a 5-month period. If the court was simply speaking generically that there were multiple events in both of these sections, if the court simply said count 1 involves multiple incidents over the course of a closed-end period of time, and count 3 involves multiple incidents over a course of another closed period of time, that wouldn't be a problem, would it?
Your Honor, I don't believe that would be a problem, but that's not what the court said here. The court initially referenced Detective Leal's testimony when it said conduct over a period of a number of years on page 20 of the appendix and 40 of the transcript. But then when the court clarified, it said that count 1's time frame was 1 year, And so the prejudice here is that the court is required to have accurate information when conducting its sentence.
Well, the court at several points says, yeah, there are multiple events taking place over a period of time. And as he says on page 20, I guess 40 is at the top of the page, is another aggravating factor. We're not talking about a single incident, as Detective Leal testified. This case is somewhat unusual in the fact that there were several multiples of incidents over a period of time. So that's sort of a blanket thing. He's saying there are multiple incidents over periods of time. And if he simply misspoke himself and said account 1 covers a 1-year period, when in fact it covers a 5-month period, that wouldn't be a problem standing by itself. And the fact that he did say over 1 year, what do we take from that? I mean, is that, he's repeatedly said this whole schmeal involves multiple incidents. Is there any damage there?
Your Honor, we think Mr. Merchant was essentially subject to a punishment not only that violated double jeopardy, because by indicating it was 1 year, from the timeline, the count 1 was October to March, October 21 to March of 22. Count 3 started in March of 22, went to March of 23. So by indicating 1 year, we believe there's a double jeopardy issue that the court was explicitly punishing Mr. Merchant based on overlapping conduct. But it's also, the indictment was 5 months, and the court's punishing him for conduct that took place over a year. And if it's just, it's instances of conduct, but there's a significant difference between conduct taking place over a 5-month period and conduct taking place over...
Well, isn't the gist of what he's saying is this was multiple incidents over a period of time? I mean, it doesn't really matter whether it's 5 months or 12 months, does it?
Your Honor, our position is that if it was 5 months, the court would have had a lesser sentence, but the court, by its own admission, was sentencing Mr. Merchant based on conduct over a longer period of time. So
but in step 2, he applies in both instances that there was a whole pile of incidents over a period of years. So in both count 1 and count 3, he's really embracing the entire period of time, which would subsume incidents that occurred under the indictment's period of time for the other offenses.
Your Honor, our concern where he references Detective Leal's testimony when it says that conduct took place over a number of years was on of the hearing transcript on page 9.
Yep.
Detective Leal testified that the conduct took place over 3 to 4 years.
Yes.
And so that concern of ours is by referencing that, the court is not only, if I may finish the answer, the court's not only punishing Mr. Merchant for conduct outside of the time frame, but it's enlarging it to a 3 or 4 year period. Thank you.
So Attorney Madigan, what are we supposed to do with the fact that the court imposed a sentence after doing a Huey analysis on count 1 to come up with a sentence of 20, and then said, didn't do a separate Huey analysis on count 2, yet imposed a consecutive sentence, said I'm importing the same Huey analysis, and the sentence is 10 years.
As the sentencing court noted multiple times, and there's almost no way to disagree with the judge's statements, that these are the most complex sentencing cases there are. Because as the court has pointed out, under a black and white analysis of count 1 and count 3, the general or the overall sentence in this case could have been 40 years, 20 and 20. Mm-hmm. Now we're into the point where the total sentence exceeds the maximum allowable sentence for any single count. So while I absolutely will never concede that this sentence is disproportionate in any way, shape, or form, I think once you've reached that point, you're now in a disproportionate sentence. And does that sentence match the overall pattern of conduct? These cases require the court, the judge who is doing the sentencing, to find the overall balance so that the defendant is sentenced on each count appropriately notwithstanding that the facts and circumstances generally are the same. And the court noted that, and even as this one quote that we keep referring to, but it goes on to say the court's general sentencing conclusions reached in arriving at the sentence to count 1 would also apply to count 3, which, as I noted a moment ago, is a separate series of incidents. So when we look at what a sentencing court is supposed to do with these types of cases, in theory, and by statute, the court could come in and say, I think everything here needs to be consecutive. Count 1 is 20 years, count 2 is 5 years, count 3 is 20 years, count 4 is 5 years, and so on and so forth, and just stack everything up. I don't believe there is anybody who would stand before this court and say that would be appropriate in terms of a sentencing decision. Might it accurately match what the court or the statutes allow? Yes, but the disproportionality considerations there.
So are
would
you
be
saying the
huge.
sentence is disproportionate?
I don't believe this sentence is disproportionate in
Okay.
any way, shape, or form.
So you're suggesting that the court perhaps had that in the back of its mind, and so was saying, the Huey analysis is similar, but I'm going to make this 10 rather than 20, so we don't have a 40-year overall sentence. You're saying this was to the defendant's benefit, essentially, is what we should infer from this?
I think that this is the court taking all of the sentencing factors into consideration and crafting an appropriate sentence for what is an 8-count indictment,
But we
separate
don't-
incidences.
But the court didn't tell us. I mean, if you're going to do consecutive sentences, so putting aside the question of whether the court needs to make, at what point and the analysis for consecutive, putting aside that, which is still an issue, doesn't the court have to do a separate Huey analysis on, I mean, he can incorporate, I'm not saying you can't say what I said before, but don't you have to do a Huey analysis for count 3 in that instance if you're going to impose a consecutive sentence?
And I believe, yes, but I
Okay,
also
but wasn't the
think,
Huey analysis, by incorporating it from count 1, he's saying the Huey analysis yields a sentence of 20 years, but the sentence that was imposed was 10. And I'm not,
Yes.
I understand that maybe 20 years would have raised a higher degree of disproportionality. But how does this follow sentencing principles or process in any way?
I think it is partially the distinction between the actual 3-step Huey analysis, and in this case, step 3 being essentially recognized and set aside because of the availability of supervised release. Looking at the totality of the conduct in all of the counts and crafting, as we do expect sentencing judges and justices to do, a sentence that is appropriate to the crimes that have been committed.
But don't we require the judge to explain himself a bit more than by saying I'm adopting the same analysis, and yet I'm going to put 10 years instead of 20 like I did when I had that analysis?
Well, I'm drawn to State v. Parker, where Justice Warren, I believe it was here, actually vacated his own sentence when he realized that he couldn't put somebody on probation, was required to actually impose supervised release. So after 4 days after sentencing an individual, he brought everybody back and said, we need to redo it. At which point he repeated his original analysis and said, that brings a sentence of 22 years, but it seems disproportionate to me that I'm going from 22 all but 14 originally to 22. So now I'm just going to make the sentence 20 years. So, and this court upheld that sentence in that case.
But this judge didn't express any of that.
No, and if the court would be looking for the judge to have said, following the same analysis, the same factors that I considered in count 1 would apply to count 3. However, I do believe that imposing a consecutive 20-year sentence on count 3 under those factors would be disproportionate. He did not say that. Those are not words he used. The end effect, and I don't know if the court would find that acceptable if a judge then said, but 20 stacked on 20 I find would be disproportionate to the conduct based on all of the factors here, and therefore I'm reducing the sentence on count 3 down to 10 years.
As an appellate court, it would be great if the judge did distinguish it somehow, because we look at it and say, oh, okay, that's why you landed at that figure, but it's devoid of anything like that, and that leaves us in a bit of a conundrum.
where he said, my analysis leads me to 20, but I'm going to do 10.
And notwithstanding that, when, again, looking at the overall final sentence that was imposed here, we can disagree, and we do disagree. I don't believe the
Yeah.
court
Do you agree
conflated 1
that
and
he's
3.
supposed, when you're doing consecutive sentences, not when they're concurrent, but when you're doing consecutive sentences, you need to do a separate Huey analysis, a separate analysis of the consecutive count?
In terms of imposing it, I think that, as the judge did here, incorporated, the facts are
I'm
the
not saying
same.
you can't incorporate some of the things you said earlier, but there needs to be a Huey analysis for that separate count, doesn't there?
Yes, I think in terms of why you're basing that second sentence. In this case, it's one of those, we go back and forth across the transcript from the beginning, where the judge actually, where this transcript as part of the appendix begins, the judge is actually referencing State v. Gauthier for some of these considerations. And although that case wasn't hugely on point here, we know that the judge started this sentencing fully cognizant of his obligations under Huey, explained the analysis quite clearly, and repeated himself throughout this. Was it as well articulated as this court would like?
Was it articulated at all for count 3 as to how we got to 10 instead of 20?
Well enough in this case.
Can you point it to me in the transcript where he articulates that?
I think when we look at, as we talked about on those pages, and the numbers, the actual transcript page, I believe, is 44, but the general sentencing conclusions would also apply to count 3, which is a separate series of incidents, and then imposes a consecutive 10-year sentence, and for the reasons articulated, or this court suspends none of that sentence. And then it goes.
That's really it, isn't it?
I'm sorry?
That's it, what you just read.
That is the crux of his determination as to why 10 on count 3 as opposed to 20 on count 3, and no explanation as to 10 on count 3.
So he doesn't distinguish. He may have something in his mind, but he didn't distinguish it on the record. Can I take you to the point that the appellant raises on appeal here? And I'll start off with a hypothetical. Person's charged with 2 offenses of theft, counts 1 and 2, and the judge sentences on count 1, goes to count 2, and says at step 2 of that analysis, and also I find as an aggravating factor that he committed count 1, throws it in as an aggravated factor to raise the sentence. Is that okay to take another count of the same indictment and use that as I'm not saying that necessarily happened here, but I'm saying hypothetically, is that okay?
As much as I would like to agree that it was okay, the facts and circumstances of even that case was it a course of conduct, or were they 2 separate incidents occurring between different victims on the same date? So there's so many different factors there that, again, only a sentencing court can consider in whether or not something should be concurrent or consecutive.
Let's say on two separate thefts, in my hypothetical, 2 completely separate thefts. One's at a convenience store, one's at a pharmacy. And he said, oh, by the way, since you committed the offense at the convenience store, I'm going to aggravate my sentence here.
I don't believe that as part of a single indictment and sentencing structure on 2 counts within a single indictment, it's appropriate to say you committed count 1,
Okay,
therefore
so how
we're
about
going
a
to
continuing course of
aggravate.
conduct?
I would hope that that indictment was a continuing course of conduct and that those counts were somehow related, because they should be.
Okay, and in this
Isn't that
case
the
here...
Downs case?
I'm sorry?
Isn't that the Downs case?
I'm afraid I'm...
Isn't that the Downs case as a practical matter?
State versus Downs, 2009 case.
I'm afraid, Your Honor, I'm not familiar with State v. Downs.
There we held that the court didn't abuse its discretion by imposing consecutive sentences based on multiplicity and appropriately considering the cumulative effects. But we also clarified that when doing so, it has to engage in separate Huey analyses.
And
that leads you to your answer to my next question, is if it's a continuing course of conduct, is it okay?
To aggravate it, I think that would apply more to the base sentence, because once again, if the court determines that it's going to impose concurrent sentencing, then I think the court can say, we're combining all of this as a single course of conduct, therefore I'm going to set the base sentence higher. And essentially within every case, 1 count is always going to be the foundational count, what the sentence is built upon. absent a decision by the court ahead of time to say, I'm doing consecutive sentences on everything. But even then, one sentence has to be the foundation sentence that the others build upon. And while that's not explicitly laid out in any single statute, by requiring the court to consider concurrent or consecutive sentences, the practical and realistic effect is that one count becomes the foundation, or in normal language we'd say the controlling sentence, that other sentences are built upon to create the overall sentence structure that is legal and appropriate for that specific conduct in that individual. In this case, the end result is a balanced, appropriate sentence. Could the judge below have been more specific as to why the 10 years on count 3 as opposed to 20 years if the exact analysis was the same? Yes. Potentially he could have been far more explicit in that analysis or in that second step of that analysis, obviously incorporating the first. But given the totality of the sentencing, the totality of the conduct for which the sentencing judge is the person in the best position to determine the final structure of the sentence, in this case, 2 consecutive sentences followed by supervised release, all within the statutory authority for these charges, was absolutely appropriate.
Is there any merger issue here, by the way, between the USCs and the GSAs?
I don't believe so. The elements within these are very different, and they can occur, while they may occur at the same time, they are very different elements as separated by the legislature. So for purposes of sentencing in these matters, no, merger would not apply.
Can you address the double jeopardy concerns that were raised by opposing counsel with respect to the determination in count 1 of the impact of the events that occurred over the different years?
Yes, and I think that when we look at the language specifically used by the court, there are the 2 separate moments that are specifically addressed. We talked about the one where the court was referencing conduct arising from separate criminal episodes involving multiple incidents over the course of a year. And in this case, throughout this entire sentencing procedure, the court was acknowledging multiple incidents, 2 separate counts, and specifically acknowledging that counts 1 and 3 were separate charges in separate time periods. They did span 2 different year periods. Matter of fact, they span 3 different year periods if we look at it. But at no point when we look at the overall structure or the language used by the sentencing judge did the judge actually sit down and say explicitly, count 1 occurred over the course of one single 364-day period, 1 year. The court was very cognizant of the fact that these were 2 separate counts and that each count involved the potential for multiple incidences. And throughout the context of this, not only in that quote that we've discussed when he's referring to the detective's prior testimony, multiples of incident over a period of a number of years, it is not unheard of for this sort of thing to do that. So I don't believe there's a double jeopardy issue here. I think the court was, as anybody would, having some difficulty with the totality of the time frame. He was referencing 2 separate time frames, nothing more.
Thank you.
Thank you, Judge.
And Mr. Baldacci, you wish to be heard in rebuttal?
Thank you, Your Honor. Our position is that by its express admission, the court conflated conduct and violated Mr. Merchant's double jeopardy rights. We'd also emphasize that we believe the sequencing issue resulted in a fragmented sentence, and finally that the sentence was disproportionate. And Your Honor, we believe that the court's failure to conduct a separate Huey analysis is also another major issue with the sentence in this case.
Is that issue preserved, counsel? In other words, did you argue that issue in your brief?
Your Honor, we argued issues with the Huey analysis, and we argued disproportionality. On the Huey issue, obviously, we argued double jeopardy and the sequencing issue. We'd note that this court has de novo review over step one in the Huey process. The court didn't really engage in any meaningful analysis, as Your Honor noted, on count 3 under Huey. So we believe this court would have the ability to address that issue.
Well, distinction, no Huey analysis or no or significant Huey analysis. You say none. There's a question that said how articulate the court was in the analysis with respect to count 3.
Your Honor, I may have overstated it. I think it was grossly insufficient.
Problem is it incorporated an analysis that arrived at 20 years and then said, I'm incorporating the same analysis, but then now it's 10.
Just, Your Honor, we believe it just shows that the Huey analysis was flawed and there needs to be a resentencing here. Thank you.
Thank you. As is our usual practice, we'll be taking this matter under advisement, issue a written decision in due course. And with that, we will be in recess on this matter.
All rise.
can be seated. The matter before the court is Piscataquis County 24-424, State of Maine versus Terri, Moulton. We're being streamed on the web, both by audio and by video. And if counsel would identify yourselves by saying your names for the record together with the party you represent.
Neil Prendergast, representing Terri Moulton.
Mark Rucci, representing Appellee, State of Maine.
Thank you. And Attorney Prendergast, if you're ready to proceed, we'd be happy to hear your argument this morning.
And may it please the court, my name is Neil Prendergast, and I represent Terri Moulton in this matter. And I believe collectively, given the different issues that arose during her trial, that she was essentially denied a fair trial based upon not only what was some questionable comments, both in opening and closing by the prosecutor, but also...
Well, green light's on, so I'll jump in. What, in your view, if you had to pick the most significant or egregious statements made, what would you point to?
Well, there are two, and both of them were objected to, I believe, by the trial counsel, Mr. Maselli. The one involving Ms. Moulton's right to a trial, where the prosecutor essentially says, well, I think she has a right to a trial, and we're not disparaging that, but when one reads the way the transcript reads, the comment is pretty much almost like, you know, Mark Antony saying, I come not to praise Caesar, but to bury him. He's saying one thing, but in fact, it's quite the opposite is what's being said, is I'm not disparaging her right to a trial, but why am I here? At least that's the way it came across to a defense attorney. The other issue I think is problematic was the one where the prosecutor brought up punishment. I don't think it's appropriate for the prosecutor to bring up punishment. The punishment is an issue for the trial court and the trial justice.
But didn't the prosecutor bring it up in the context of we're not here to decide punishment?
He said we're not here to decide.
Which is really what the judge will tell the jury, that you should not be concerned with punishment.
Correct, but I would think that that's a responsibility for the trial judge, and also an experienced prosecutor should know that bringing up punishment is likely to become an issue, if nothing else, because of this court's jurisprudence. And something like the State versus Jomo White, where this court has said that, you know, encouraging a jury to hold the defendant accountable is considered problematic in terms of constitutional protection. So if, I don't know that I fully answered your question, Justice Lawrence, but if I had to pick the top two, those would be the top two statements that I think are problematic. In a larger sense, I think the other issues that I raised were essentially that there is a case theme that the prosecution brought here about trust and betrayal, and there seems to be a thread throughout all of it, where this is about a betrayal of trust, this is about this is about it. Again, I understand that everyone has to have a theory of the case, and as somebody who's tried cases on both the prosecutorial and the defense side, I understand that what you're trying to do as a trial attorney is to distill your theory of the case in about a sentence and go in front of a jury and say, this is what this case is about.
And that is what usually, essentially, embezzlement cases are. I mean, they do feel like a betrayal.
Yes, they do feel like a betrayal. They can feel that way, but I think in this particular case, I think the way that it pervaded both the opening, the closing, and even the rebuttal, I think it was trying to evoke some amount of sympathy or jury sympathy or, excuse me, I'm stumbling a little bit. You know, statements pandering to jurors' sympathy, bias, or prejudice. It's basically saying if you find this person not guilty, then, you know, there is no betrayal. If you acquit this person, there's a problem.
Well,
now, obviously, in effect,
part of the problem too. I mean, betrayal is not a crime.
Correct.
Right. I mean, embezzlement's a crime,
Correct.
and you could betray someone, and it's might be something that we find morally reprehensible, but it's not criminal. And so, is your argument that this theme sort of doesn't really speak to the elements of the offense?
that is what I argued, and I do think that, yes, in terms of embezzlement, when we're talking about matters of proof, I think it has to do more with the technical issues. Was there money? Was it missing? Whatever. Not this person is responsible for this other person not having any money anymore, and you should find them guilty. And
Suppose we agree with you that there were some errors here. Why aren't they harmless given the nature of the evidence against your client here, which involved a pretty straightforward confession?
Well, I mean, I think they're not harmless in as much as you can't. I don't think you can separate, and I don't think you can have a constitutionally adequate trial where a prosecutor is basically impugning the idea that you have a right to a trial. Well, maybe you don't. If you confess, you shouldn't be here. I don't think they're harmless error, and especially because the trial attorney caught them, I think they did end up prejudicing the jury here and the process, and I think that they may have, in fact, resulted in a verdict that cannot be relied upon. But I'm sorry, I already forgot the first part of your question, Justice Lopez. Would you mind asking it again?
No, I think you'd answered it. It was just that if we find error, I mean, there was a confession here. How are we to, why, given that, could the state not sort of meet its burden to show that it's highly probable that any error didn't affect the verdict, given the nature of the evidence?
Well, considering that my client didn't testify, and that came from, obviously one of the state's witnesses, I think that there was some prejudice here in saying, she confessed. She's never cross-examined, and she had the right not to be, obviously. But I think, given the way that it played itself out, I think that there was, in fact, enough prejudice that it does render the verdict in this case questionable. But I think,
notwithstanding the video of her discussion with the officer as to what the circumstances were, that was about, if I remember, 6 or 7 minutes long, and
correct.
Basically, it's a conversation between two people in which she's acknowledging.
Well, it is a conversation between two people, and it's somebody that she'd known most of her life. And so, it didn't take the appearance of a custodial interrogation, although, because it was done in her home, of course. But, even so, I think that even if there is a confession, I think the prosecutor's job is to keep it technical and say she confessed, which is fine, but not to take an issue that says she confessed, why are we here, why are we having a trial? Those are two different things.
And the other comment the prosecutor in this case made was, never did she speak up and say, I'll know what some of the problem is, not all of it, some of it. What kind of mindset would that person have, knowing you're being relied on, being trusted? Sit right there and not say anything. She
Right.
didn't testify in the case either, right?
Correct, she did not.
I mean, are you viewing that as a comment on the right to remain silent?
I think so, but I think also it's sort of a burden shift as well. I mean, part of the prosecutor's job is not to try and shift the burden to a defendant, and, I think maybe those are both the sides of the same coin, Justice Stanfield, but I mean, the way I took that was it was saying, why is she staying silent, I mean, even in fact, I think, if I'm not mistaken, and I don't have a photographic memory, but there was something in the rebuttal that had to do, I think it was in...
That was the rebuttal.
Okay, that was rebuttal, and that was, I think, on page 80 or 81 of the day 4 of the trial transcript.
I was looking at.
So I think that's what you're referencing. So I think both are probably accurate, Justice Stanfield, that, maybe he's taking issue with the right to remain silent, maybe there's a burden shift going on, but there's definitely something there. Moving forward, I think the other issue that I wanted to address with the court, I think, which was problematic, was the issue of the trial judge not recusing himself from the case, given the overall situation. I think that...
How long is that supposed to go on, though? I mean, in this case, let's be clear, he had been a judge for quite some number of years, and although he had worked in the prosecutor's office, it actually wasn't in the same office.
Right, but he was also Chris Almey's deputy district attorney, and also...
Is that the difference? I mean, we have a lot of former judges who were prosecutors.
We do, but for the most part, the judges who are former prosecutors don't walk into court and start making judgment calls on cases that involve their former boss making the arguments either.
No, I'm not sure that's true.
Well, I mean, that has been happening in Aroostook County, but in a case like this where it's close, Justice Stanfield, you and the other justices here have made certain comments, in your... I believe it was in the state of the court address, but certainly there were a couple of decisions that came out of this court that people need the ability to believe in the process and the impartiality of the process, and that people are losing faith in institutions. From a poor defendant's perspective, they get charged with a crime, they go to court, and then they have some arguments about discovery, and then they get to court, and the person on the bench is the prosecutor's former boss that then says, you can't have a continuance. No, we're going forward with the case. Oh, don't worry about the discovery issue, we're going forward with the case. And then when the prosecutor is making all of these comments, and many of them are being objected to, none of those are a problem either. I think that at some level...
When we talk about appearance of propriety, though, I mean, I know it was specifically argued that in this case the defendant didn't have confidence, but it's an objective standard, isn't it, when it comes to appearance of impropriety?
It is an objective standard, I agree, Justice Stanfield, but I think in this case, anybody who wanted to question the integrity of the process, given the way that the facts of this case played itself out, would reasonably be able to do so. There's a point where...
Where is the line, counsel? I mean, I think the chief asked this question, but I'm not sure I heard an exact answer.
Well,
does it have to be a period of time? Does it have to do with your role in the office previously? I mean, the judge made a record, we're not friends outside of work. We haven't socialized. It's been 9 years.
The practical answer I would give to you in this particular case, Justice Lopez, would be this. I think that judge probably could have sat on other cases from that prosecutorial district, but in terms of the impartiality standard, I think he should not have been sitting in in a felony case where there were multiple years in prison on the line, making
Well, if there's
judgment
an
calls
appearance
first
of
or-
impropriety, there's an appearance of impropriety regardless of whether it's a felony or a misdemeanor or, I mean, I understand there may be more at stake because it's a felony. but-
Right, well, okay, but fair enough, and I get that. But I mean, in my experience in family court, whenever I walked into family court as a family attorney, if I walked in and the judge had been in private practice or law practice with the other attorney, the instinct of the judges when I first started practicing was to instantly disclose that. Hey, we practice law together. How do you feel? Do you want to go forward?
But
The
doesn't
judge
that
in this case
disappear?
didn't even bring that up. There
Doesn't
was-
that disappear after a period of time? I mean, for example, I was associated, in fact, I was a partner in a law firm a million years ago, okay?
Sure.
It's been a long time. It's been 20, whatever, almost 30 years. And there aren't even any people still there who were there when I was there. I mean, do I have to say something about that firm?
Well, no,
I
but
don't,
if, but,
to be
but,
honest.
but if there's no people who were there now that were there,
Is that the issue?
I think your situation is distinguishable based upon the fact.
So
that you just
if
gave
there
me.
were still one or two people there that, I mean, 30 years later, am I still supposed to say?
If they're the one that's filing the brief and arguing the case, maybe. I would think, I mean.
Is the difference here that, did I hear you say that this judge had been the deputy DA?
It's right in the record. He said he was the deputy district attorney for Mr. Almy.
Is that the difference here, that he held a position of trust?
He held the position of trust and authority, in fact. I mean, when a deputy district attorney does more than just prosecute cases, they handle administrative things. When other people have questions, they usually, at least when I was a DA, they would call the deputy DA, not the DA. I think it's certainly a difference in this case. that
Can you
is
point to
significant.
any suspect judgment calls or action by this was a jury trial. The judge didn't make the final decision here. Can you point to anything that looks suspect on the face of it?
Well, yes. I mean, not only the lack of a continuance, but then also.
So you think he denied the continuance because he had a relationship with the district attorney?
I can't say, but he was placed in a position where either he was saying that his
Well,
former
you're saying
boss-
he made errors. You
He made
can't say
errors.
that it's because of the
Right.
relationship, but he made errors.
To try and answer the question, either he was going to take issue with his former boss's discovery and his former boss's statements during the trial and either deny those because of the way that the case played itself out, or he was going to say that it was fine. At some level, probably he shouldn't have placed himself in a position to be in a situation where he had to be on either side of that coin.
What's the standard for review for the judge's decision not to recuse?
I had it in my brief. Now I'm blanking on what the actual standard is here. But
I think it's abuse of discretion.
yeah, okay.
I mean, isn't the judge the person that's in the best position to make that call?
Well, I mean, I think somebody can argue that it is. I just don't think that the judge made the right call in this particular situation. And I don't think, ultimately, that given all of the other things that took place here, I think that it's sort of when you combined all the things that went together, I think it still denied Ms. Moulton a fair trial. And
But
I
she's
think
still, on the discovery point, though, if that was one of the judgment calls that you're questioning, it was a password issue, but she still had access to the physical documents, did she not?
right, but she didn't have access to what she needed to do to recreate what the QuickBooks looked like.
Was there a
before
motion to compel that was refiled? There wasn't, I mean, to be clear, there was no motion to compel refiled in a timely fashion in order to get that information. I understand you're really basically saying we want to be able to do a deeper dive in terms of the analysis.
Correct.
But there was no motion to compel the disclosure of that information.
Well, there was a motion to compel discovery
But
that
it
was
was
filed
withdrawn.
in the case. It was, but only after the trial counsel was promised he was going to
But
get the
that was like a
discovery.
year before trial.
Well, I mean, I guess, without going on, I see the light is red, but I guess the question is, how many motions does a defense attorney need to file in order to get discovery in an issue like this when you're having the discussion throughout 2 dispositional conferences and a judicial settlement conference? I mean, he could have filed multiple other motions, but I'm not sure that those would have had any effect to get given the overall tenor of the case, I'm not sure that those additional motions would have had the effect that the defense attorney was looking for. Thank you.
Thank you. Attorney Rucci, are you still in ADA?
I am an AAG, Your Honor. Good morning, and may it please the court. Lest I bury the lead, I'm compelled to say that even assuming arguendo, any of these errors assigned in Moulton's brief have merit, none require vacatur of the jury's verdict. For all of the reasons that have been discussed here today, Ms. Moulton had an absolute right to a trial which she exercised. That's not to say that her case was, to borrow a phrase that we use in the trial courts, triable, meaning a case with a relative chance of success on the merits. Here, Moulton made several confessions of theft to multiple parties, including video-recorded confession to a sheriff's deputy that included both an explicit admission of theft and an implicit admission to an amount far greater than $10,000 when she admitted that each payment made to someone that was easily recreated in bank statements was her. To borrow another phrase used from the trial, well, from the state's perspective, Ms. Moulton's guilt was determined beyond any real doubt, and any error that was made was harmless. That said, the prosecutor did not err in explaining to the jury that Ms. Moulton had a right to a jury trial they needed to respect, or in stating that their sole consideration in deliberation was to determine guilt or innocence rather than to determine punishment. The prosecutor did not commit a discovery violation in not turning over passwords that he did not have in response to a motion to compel that was withdrawn. And finally, the prosecutor chose an appropriate, and perhaps the most appropriate, theme for a trial wherein an individual who described herself as a member of the company family stole hundreds of thousands of dollars, which was trust and betrayal. He frequently reiterated that theme throughout his opening, closing, and rebuttal, and that was not impermissible. It did not play on the jury's sympathies. It did not inject his personal opinion. It was simply a theme of the trial that he used. The verdict of the trial court should be affirmed.
It sounds like what the argument here is on some of the comments made by the prosecutor, is that essentially they were delivered, and the words may have been accurate, but they were delivered with an eye roll, shall we say.
Well, Your Honor, that's exactly why we defer to the trial justice in looking at evidentiary rulings, and particularly rulings during, openings and closings. I understand what Attorney Pendergrast is saying, but that's his interpretation based upon the cold record, and even he said that's what it looks like to a defense attorney. None of us were there to hear that comment. The judge was there to hear that comment. He expressly said, I'm not going to opine as to whether that really was opining Ms. Moulton's right to a trial. What the cold record says to the state is she has a right to a trial, which is exactly the state of the law. So from the state's perspective, it should really be left to the judge who was there to...
Couldn't it be interpreted as, yeah, she's got a right to a trial, but this is really kind of a pro forma exercise that we're going through, and we all know she's guilty? I mean, I understand your argument that we have to defer, it's a cold record, but that's at least on the cold record sort of how it reads. Why are we having a trial?
I'm not willing to concede that that's how it reads, Your Honor, but I would say that the only person who would really have an opinion of that, which was based upon actually viewing the comment as it was said, was the trial judge, who did not find it to rise to the level of warranting a mistrial.
Can I ask about the trust and betrayal themes?
Yes.
And I'll give you, I guess, a hypothetical. In a drug trafficking case, one could argue that a drug trafficker is sort of exploiting users' need for pills or heroin or whatever it is. Would it be appropriate for a prosecutor to say, this is a case about exploitation?
Yes.
You think that would be an appropriate theme in a drug trafficking case where the question is just whether the person had knowingly distributed drugs to another person?
I think that would be an appropriate theme, Your Honor. Yes.
Why?
Because, now, of course, these are all matters of degree. Could the prosecutor cross a line and say, these poor people, really harp on it? Absolutely. But if the argument in opening is going to be, you had a vulnerable population that this person, say the facts are this person came from out of state and moved into a population and started selling, I think it's perfectly appropriate to say, this is a case about exploitation. This is a case about an individual who, for selfish monetary reasons, moved into a vulnerable population and sold drugs to the people there.
And what does any of that first part have to do with whether there's evidence that the person sold drugs beyond a reasonable doubt? I mean, isn't there, I guess that's my question, how far can you push the theme when it really seems like it's designed to play on a juror's sympathies as opposed to their evaluation of the evidence?
I think it's a matter of degree that a trial judge would be in the position to say, we need to tone this back, but just saying a trial is about exploitation, there's nothing from the state's perspective inherently prejudicial, inherently wrong with that statement.
As I read the statements of the right to trial and punishment, I think all of the lawyers in this room, through use of voice inflection, gestures, and all the rest of it, could deliver it with two completely different meanings, just by how they deliver it. But on this record here, we just have the black and white recitation here. How far can we go? I can read each of these as being completely appropriate, just absolutely standard, something would be completely appropriate. I could also read them as something might be inappropriate, but it all depends on how they're delivered. I won't give you an example of that. Richard Burton, the actor, used to say, I can deliver the same line and people will laugh. I can give you the same line and they'll be horrified or they'll cry. It's all in how it's delivered. Do we just defer to the trial judge to say, no, I heard that and I heard how it was delivered, and I find it was just, the prosecutor say, you don't have to, punishment's up to you. That's up to the judge. That's not part of what you're considering here. Or everybody has the right to have a trial, and that's what's happening here today. This is, part of what a defendant's right is, so don't use that against them. How far can we go on the cold record?
You should defer to the trial judge, Your Honor.
Isn't that compounded here by the second issue, which is being asserted? That isn't the problem at least I say compounded, but confused by the assertion that this trial judge had a professional and relationship with a position of trust with this prosecutor?
I understand the question, Your Honor, and if this court finds that the trial court should have recused itself, then certainly the issue of, and if this court finds error in any of those statements, then I guess you could look at them that way. But from the state's perspective, there really was no reason for Judge Roberts to recuse himself in this case. He hadn't been with the DA's office for nearly a decade. He hadn't had a personal relationship with Attorney Almy. I think his words were since leaving the office. From the state's perspective, that was also well within his discretion. Now, if there is a world, I suppose, and it's certainly the argument that Attorney Prendergast is making, where you say, look at all these errors. They are evidence of the fact that this judge was biased and should have recused himself. But I think you have to make those two, before determining whether those play into each other, you first have to determine, was there any error, which the state suggests there was not, and then you have to determine, should this judge have recused himself on the basis of the record? I'm not sure that there's any precedent for really compiling those issues and saying, let's put it this way, Your Honor, I'm sorry. I think I can put it more clearly. If you find there's error, it doesn't matter, that was not harmless, that rises to the level of warranting a mistrial, which the state asserts there was not, then it doesn't really matter if Judge Roberts should have recused himself or not. If there was no error, I would suggest to you that even if you found maybe he should have recused, which I suggest there's nothing on the record to suggest that he should, that doesn't mean that the verdict of the trial court needs to be overturned, because you're looking at the record finding no error, and the jury was the one rendering the verdict in this case.
Can I ask you about the thematic description that the prosecutor used here, the betrayal of trust and so on?
Sure.
When the trial is whether or not a person has violated the law, does it take it to a different dimension when the prosecutor brings up a moral failing, which we're not trying people for moral failures, we're trying them for whether or not they did X, Y, and Z. Does that paint or taint the case to say not only did they violate the law, but they have committed an egregious moral failing?
I'm not trying to dodge the question. I have to return a little bit to what I said to Justice Lopez, which is it's a matter of degree. Here, the theme, trust and betrayal, that was fairly in evidence, Your Honor.
But But is it? I mean, I think following up on what Justice Mead is saying, again, I'm looking at this rebuttal, and the prosecutor is making this about character. He's not making it about what she did. He says, state of mind is an issue, and then what he says is, never did she speak up and say, I know what some of the problem is. What is the state of mind in the person in that situation based on the evidence? What kind of person would that be based on the evidence? What kind of mindset? Just imagine, folks, you're being relied on, and you sit there and you don't say anything. That's sad. That's really sad. That's a betrayal. I mean, how is that arguing the facts? How is that not an attack on character that is completely outside of the facts of the case?
Well, it was based upon her interview for one point. The second point, and this is sort of an aside, I don't believe that any of those statements were objected to.
Yes, it was, actually.
Oh, it was. Okay.
It was.
Well, then I apologize.
It absolutely was. Mr. Maselli immediately said, I want to be heard, and raised exactly that issue amongst others.
Well, then I apologize, Your Honor. From the state's perspective, it's left to the discretion of the trial judge to determine what remedy, if any, there is for those statements.
In this case, although it was raised, the trial judge didn't actually even rule on it, I don't think. Kind of odd.
I'm sort of remembering now that it was like they just sort of moved past it, I think. I don't know that it was briefed, but at any rate, Your Honor, from the state's perspective, I mean, the jury had the video of her admitting some of the theft and
I understand
then saying,
that. But the prosecutor is arguing here is that this is a character flaw, that it's sad, and it's a betrayal. And those are not issues that go to whether or not the offense was committed.
I understand, Your Honor, and given, if that's the court's perspective, and I understand it, it sounds like it is, the question then is whether it's harmless error, and in light of all the other evidence, we would suggest that it is.
It's not unusual for counsel in closing to characterize what happened, and it's a child abuse case for a prosecutor to say, this person did something terrible. They abused this child. You know, it's a terrible, terrible thing for an adult to do to a child. That really doesn't go to the facts of the case, but the prosecutor is saying out loud what probably everyone else is thinking. And in a case like this, where it's an employer, long-time employee relationship, they know each other, probably a lot of the jurors may be thinking, oh, boy, that's a real breach of trust. Is it wrong for the prosecutor to say out loud what probably everyone's thinking at the time?
No, Your Honor. I think it's an appropriate use of trial themes. I think it's fairly based upon the evidence to say this is a matter of trust and betrayal.
The jury may be thinking, this is a miserable person. Can he say, this is a miserable person?
I mean, isn't that the difference? You can say that the difference between saying this is a terrible act versus this is a terrible person.
I had to make sure I wasn't being set up, Your Honor. No, you cannot say this is a terrible person. You can't say this is a,
right, there are boundaries. There's a continuum. Here's how far you can go with it.
There's a continuum of conduct, Your Honor, and the state's position is that the prosecutor in this case didn't venture into the territory from which to which he was not supposed to. And if there's no further questions, I'll see the rest of my time.
Thank you. And Mr. Prendergast, I think you reserved a couple minutes for rebuttal.
I did, and I'm going to keep it very brief. You would ask me, if there's a time limit to how long a recusal should take. Is it 10 years? I didn't have an answer. I still don't have an answer. I couldn't find any case law that had an answer. That's why I don't have a better one for you. But I think the practical answer that I would have is that in a case like this, if the judge was going to recuse himself, he wouldn't have to. I understand the court's view of recusal is once you recuse yourself from some office's cases, somebody might take the position that you have to recuse yourself from all of them. I don't think that this judge had to recuse himself from every case out of this DA's office, but I think he should have recused himself.
Well, I think where most of us would, and I'm just sort of speaking maybe for myself, would draw the line on the difference between something that is uncontested, a plea that's agreed to plea, correct, and it's disclosed, you might take that, but you wouldn't do something that's contested.
Correct, and I think that's, in this particular instance, I think that's probably sort of where, my head is going, and the idea is, if I've got a former DA on the bench and someone else, if we've got an agreement, that's one thing, but when it's contested, I think it's different. Thank you.
All right, thank you. As is our usual practice, we will be taking the matter under advisement, issuing a written decision in due course. And with that, I think we're on the lunch recess.